This courtroom exchange quickly turns intense when a man tries to use sovereign citizen arguments to avoid basic legal responsibility. From the very start, the defendant refuses to confirm his identity, claiming he is a living soul and not the legal person named in court records. Instead of answering simple questions, he cites obscure codes and pseudo-legal phrases, clearly attempting to derail the proceedings. But the judge immediately takes control. Calm, firm, and direct, the judge makes it clear that this court will not entertain word games or philosophical arguments. The defendant is given a clear ultimatum: answer yes or no, or the court will treat his behavior as a failure to appear and issue a bench warrant for his arrest. Faced with real consequences, the defendant suddenly complies, while repeatedly claiming he's being coerced. The hearing then shifts to the real issue: more than $14,000 in unpaid child support. The judge orders that a previously posted bond be forfeited and applied directly to the debt, rejecting the defendant's request to return the money to his friend. Still, the defendant keeps pushing irrelevant claims, questioning the court's authority and referencing imaginary financial instruments. At that point, the judge has had enough. The defendant is muted, his arguments dismissed as legally meaningless, and the case is placed under continued court supervision. This moment is a powerful reminder: courtroom theatrics don't override the law, and responsibility can't be talked away.
Case in accordance with SPR 89363, which is a court order to full faith and credit.
I'm going to state one more time, and then I'm going to allow a response. The answer is either going to be yes or no, and the answer to that question will determine whether or not you're involved in this hearing or not. But I don't allow ridiculous comments to be made, and I don't allow litigants to control the method of this court proceeding. Instead, I ask simple, identifying questions, because I've just called the case, and the case is called Katrina Thompson versus David Thompson. If the answer to the question I'm about to ask is yes, you're going to be entitled to proceed and be heard in this case. If the answer to the question I'm about to answer is no, you're not associated with this case and you won't be able to be heard. So the answer to the question is, are you David Glenn Thompson?
I am that living soul allowed to use that? Yes. I am that soul.
Mr. Thompson, it's either a yes or no, or you're not going to be involved in the hearing. Let me take it a step further and let you know what happens if you are not David Glenn Thompson. My next question will be, is there any other David Glenn Thompson in the courtroom or otherwise? If I hear the answer to that question, no, it's likely that the court will issue a bench warrant for non-appearance. So it's your last chance to tell me.
Sure. Yep. Yes.
Are you David?
I feel really coerced right now. Thank you. I appreciate that.
You David Glenn Thompson?
I believe I just answered that with a yes, and I feel really coerced right now.
Mr. Thompson, I'm not going to allow ridiculousness to control the day in this court proceeding. I don't view this office as needing to allow that, and the law doesn't view this office as needing to allow it. I have a simple and straightforward job to proceed with. If you make that job difficult or impossible, I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you. So when I ask you if your name is what you're listed as on this docket and you tell me you feel coerced, I respond by indicating this: you can participate in this hearing if you're reasonable. If you're not reasonable, I'm going to remove you from the hearing. Am I clear?
Well, I do apologize. You're very clear. I'm just trying to correct errors upon your record.
This record, again, Mr. Thompson, is clear, and it will be more clear if you let me proceed further past what should be fairly innocuous, which is whether or not you're a named party. Now that we've gotten past that rather innocuous, fairly clear point, the next really clear point is this. You're here today, Mr. Thompson, because there's an allegation that you've not been paid to support as ordered by the court. If you're found to have not been making reasonable payments out of your available income, the court could hold you in contempt, and contempt is punishable by potential jail. In this case, we're also here to address a bond that you had previously posted. So, when you posted a bond, I ordered that a hearing would be set today. When I set that hearing, it's to address several things. Number one is to address the issue of contempt and whether or not I should forfeit the bond that you previously posted. The order specifically indicated to you why we're here, but because there appears to be difficulty in you understanding that, I'm going to go through it. Defendant is required under the terms of that written order that you got a copy of to show cause. Well, you should not be held in contempt for failure to comply with the court's order. If you fail to appear, you can be found in contempt and a bench warrant can be issued. If contempt is found, the court can apply any enforcement remedy allowed under the law. The bench warrant is discharged. So again, that's the requirement of the prior order. It enunciated clearly that you were going to appear here on December 5th, and I'm glad that you're present to be able to address those issues. So Ms. Spillane, let's start with the bond. From the friend of the court standpoint, are you asking the bond to be applied towards any outstanding arrearages?
Yes, sir, we are.
Mr. Thompson, did you hear the suggestion by the friend of the court?
I did, and unfortunately, I did not put the bond up. A friend of mine put that up.
Well, the bond is required by statute, Mr. Thompson, and the reason it's required is because when you have outstanding arrears, the law says that if I issue a failure to appear bench warrant, as I did in this case, that I have a statutory duty to impose a bond in the amount of 25% of the outstanding arrears or higher based upon my determination. So the amount of the bond that was posted on your behalf is going to be ordered to be forfeited towards the outstanding fines and outstanding child support arrearage. I understand your request, but I'm also confident that the person who posted bond in this child support related matter is, or should be aware of the fact that when posted, it could be utilized for those purposes. So I note your objection, but I rule otherwise in order that the bond that was posted will be forfeited towards the ongoing support obligation and or any arrearages. Once that's done, Ms. Spillane, can you tell me in general, what is the outstanding arrears, if there are any, and what is the outstanding monthly support obligation?
Your Honor, this is an arrears-only case. Once that bond payment is credited to his account, the total balance would be $14,833.05.
And does friend of the court have any suggestion on what we should do outside of having the bond forfeited as I've ordered already?
We would like to refer the defendant to the referee to monitor payments going forward.
Mr. Thompson, did you wish to be heard on that suggestion by the friend of the court?
I don't even know what to say. I don't really feel that it matters what I say. You just do what you want. So, I mean, I'm looking at court orders in front of me. I'm looking at House Resolution number 10 saying, you can't ask for money because of the bankruptcy. I don't even believe this is an actual Article 3 court. But hey, here we are. And I'd like to know what happened to the promissory note that was sent in 2017 for $20,000 gold equivalent. Registered mail to Clerk Divider, I think it is. And why that wasn't credited to the account. Since that would be a securities under these laws here.
So the court would note that I've exercised my discretion to mute Mr. Thompson. I'm going to do my best to explain why. This court proceeding has started difficult. It appears to be proceeding difficult. But it's really not a difficult understanding or case to understand in terms of the background. The background is that years ago, this case was instituted. It's a 2017 case number. It was instituted as a support matter. As the Ms. Blaine just indicated, this is a support arrears only matter, which means there's no longer any support that's currently charging, but there are outstanding arrears. Arrears means, of course, that there was a prior court order, and that court order was for Mr. Thompson to pay support. Mr. Thompson either did challenge that and was found not to have a legal challenge to that amount, or he didn't challenge it. And either way, the amounts have been, for years, been determined to have been owed. The amounts have not been paid, however. And even after this $5,600 bond has now been forfeited, the total of arrears are $14,833.05. That's not an insignificant amount. When pressed on that issue or questioned if he wanted to be heard, rather than be heard on what the friend of the court issued, which is a fairly, I would say, insignificant request to have the payments going forward monitored through a referee process, Mr. Thompson chose instead to bring up things that have nothing to do with this case. For example, I think, rather oddball claim that this is not an Article 3 court, or things referencing a surety contract, or other words that, although they seem quasi-legal, don't bear any particular relation to this. And so the court is left with the suggestion of the friend of the court on what appears to be a fairly innocuous arrears-only matter. And I keep saying fairly innocuous to the court. This is not a difficult factual determination. It's not a difficult legal determination. An order was apparently in place. It ordered Mr. Thompson to pay. He's not done so. Arrears are in the nature of almost $15,000 after the bond was applied, and yet there's claims about promissory notes and other words that I've heard but don't understand how they have any relationship to this case. And I'm quite confident on the record that's been made so far, if I allowed Mr. Thompson to be heard further, I would become more confused, not less. And so it's important for me to note that every opportunity is given to litigants to be heard. Those limitations, some limitations on that right to be heard, are present in this case, and that is, I allow litigants to be heard if it's responsive to the question set forth. If it's not responsive or relevant to the question set forth, I don't find it helpful. And I wouldn't find it helpful if the friend of the court offered things that weren't relevant to the issues at hand either. So again, the court has exercised its discretion to bar any further oral argument by Mr. Thompson. Instead, I'm going to follow the suggestion of the friend of the court. I'm going to refer this case to the referee docket for continued maintaining and watching over whether or not these payments are made going forward. I will, of course, maintain jurisdiction over this court, over this case. I'm simply referring this case to the referee for further proceedings, and I'll also sign that order once it's presented by the friend of the court, ordering that the bond that was posted on Mr. Thompson's behalf is forfeited towards the outstanding arrears only in this matter. Do you have any questions, Ms. Boyd, on this case?
No, sir.
All right, thank you. The court is at recess on this matter.
The courtroom is quiet at first, but the tension is obvious the moment the defendant comes on the screen. What should have been a routine hearing immediately turns into a standoff when the judge asks a simple question, one that most people answer without a second thought. Instead of confirming his name, the man pauses, then launches into a rehearsed explanation about being a living soul. He claims the name listed in the court records is not actually him, but merely something he's allowed to use. From the very beginning, it's clear he believes words alone can shield him from the authority of the court. He speaks carefully, choosing phrases that sound official but don't actually mean anything in real law. He refers to himself as separate from the legal identity the court recognizes, insisting there is a difference between his physical being and the person named in the case. The judge listens, expression unchanged, allowing the man just enough room to reveal exactly what strategy he's trying to use. As the defendant continues, he references obscure numbers and supposed legal codes, hoping the complexity will confuse the process. His tone is confident, almost smug, as if he believes he's discovered a hidden rule that places him beyond the court's reach. But the judge doesn't engage with the fantasy. Instead, he calmly brings the conversation back to reality, repeating the same question and making it clear that this courtroom operates under established law, not personal interpretations. When the defendant refuses again, the judge's patience runs out, not with anger, but with authority. He explains that the court is not obligated to play along with evasive answers. If the defendant refuses to identify himself, the court will treat his behavior as a failure to appear. And a failure to appear doesn't lead to debate or discussion, it leads to a bench warrant. The shift is immediate. Suddenly, the stakes are no longer theoretical. The defendant's voice changes as he realizes this isn't a philosophical argument, it's a legal proceeding with real consequences. After one last attempt to talk around the question, he finally answers. He confirms his identity, but not without repeatedly stating that he's doing so under coercion. He wants it on the record. He wants to create the impression that he's being forced against his will. The judge doesn't respond to that claim at all. Instead, he moves forward, because now that identity is established, the real reason everyone is here can finally be addressed. The hearing turns to child support, specifically, thousands of dollars in unpaid obligations that have accumulated over time. The total is staggering, climbing well past $14,000, and the record shows a consistent pattern of non-payment. As the judge reviews the history, the defendant's earlier confidence fades. The pseudo-legal arguments disappear, replaced by interruptions and deflections. He tries to shift attention away from the debt, suggesting misunderstandings, technicalities, anything that might slow the momentum. But the numbers don't lie, and the judge doesn't allow the focus to drift. Then comes the issue of the bond. A friend of the defendant had previously posted more than $5,000 on his behalf. The defendant insists that this money should be returned, emphasizing that it belongs to someone else. He speaks as though this argument alone should resolve the matter. The judge explains, clearly and firmly, that the purpose of a bond is to ensure compliance with court orders. Since compliance has not happened, the bond will be forfeited and applied directly to the child support arrears. The defendant protests, raising his voice, repeating the same point as if repetition will change the ruling. It doesn't. The judge makes it clear that this is not punishment, it's enforcement. The bond is doing exactly what it was meant to do. Still unwilling to accept reality, the defendant pivots again. He begins questioning the legitimacy of the court itself, suggesting it may not be an Article 3 court. He references unrelated bankruptcy resolutions and makes vague claims about jurisdiction, hoping to reopen a door that has already been firmly closed. Each statement drifts further from relevance, but he continues talking, refusing to recognize that none of this applies to his case. Then he brings up something even stranger. A supposed promissory note involving tens of thousands of dollars in gold-backed currency that he claims to have sent years ago. He implies that this mysterious document somehow settles or offsets his obligations. The judge doesn't entertain the idea for even a moment. There is no record of such a note, no legal mechanism supporting it, and no connection to child support law. At this point, the judge labels the commentary for what it is: nonsense. Not harshly, not emotionally, but definitively. To prevent further disruption, he mutes the defendant. The courtroom finally becomes quiet, and with no interruptions, the judge delivers the ruling with clarity and finality. The case will remain under court supervision. Payments will be monitored closely through a referee docket. The court retains jurisdiction, and future attempts to avoid responsibility through wordplay will not be tolerated. What began as an attempt to outsmart the system ends with the system asserting itself completely. This hearing serves as a clear reminder that courts operate on law, not loopholes. No amount of invented language, obscure references, or self-declared status can erase legal obligations, especially when it comes to child support. In the end, reality always outweighs rhetoric, and accountability always catches up.